Hey there. Today I want to give you an update about the case between Dr. Jordan Peterson and the College of Psychologists of Ontario. The case is going to be heard at Divisional Court in Ontario, in Toronto, tomorrow, Wednesday, June 21st. And we, the Canadian Constitution Foundation, will be appearing as an intervener in support of strong protections for the right to freedom of expression and speech. I can't wait to tell you all about it. If you're new here, welcome. My name is Christine and I'm the Litigation Director with the Canadian Constitution Foundation, a legal charity that fights for fundamental freedoms in Canada. I upload regular videos about our ongoing cases and about other interesting developments in constitutional law in Canada, so if that sounds like something you'd be interested in, please hit like and subscribe below. It really helps my videos out a lot. Also, please remember, nothing in my videos is legal advice. If you have your own legal question or problem, please consult your own lawyer. So those of you who subscribe to the channel should already know a little bit about this Dr. Peterson case fighting the College of Psychologists. It's also received a lot of media attention, so you may be familiar with it through those channels. I will link below to my other videos about the case, but for a brief recap, there were some complaints made about Dr. Jordan Peterson to the College of Psychologists, which is the regulator for psychologists. And these complaints were made by members of the public, not by patients of Dr. Peterson's. The complaints were about public statements that Dr. Peterson had made about public figures, politics, celebrities, climate change, the Freedom Convoy, and things like that. They were not directly about the practice of psychology. In response to these complaints, the College of Psychologists conducted an investigation, and they found that Dr. Peterson's statements violated the Code of Ethics for Psychologists and therefore the standards of professional conduct. So the college ordered Dr. Peterson to complete an education program to address what they called issues regarding professionalism in public statements. Now, Dr. Peterson responded to this by saying he will not do mandatory re-education. So he brought an application for judicial review of that order telling him to go for this, what he calls re-education. And that application for judicial review is being heard at the Ontario Divisional Court. And one of the things he's doing is challenging the constitutional validity of the code and the standards, which are all enacted under provincial law. So what we do at the Canadian Constitution Foundation is defend fundamental rights and constitutional principles in the courts of law. So we applied for and were granted status to intervene in Dr. Peterson's case. That means we aren't making any argument about what the outcome should be, but rather about the broader principles at stake in this case. And there are a lot of them. We are going to be arguing that professional regulators, like the College of Psychologists, cannot regulate off-duty conduct unless they can establish a clear nexus between that specific conduct and the legitimate interests of the profession. And where off-duty conduct engages a charter-protected right, like freedom of expression, regulators, like the college, have a heightened duty to ensure that they have given full effect to those charter protections. From our perspective, the important point isn't whether we agree or disagree with the things that Dr. Peterson has said in those public statements on social media. It's about whether those statements can be sanctioned by his professional regulator when he is arguing that they have nothing to do with the practice of psychology, and the complaints were brought by members of the public who basically just don't like him. Now, of course, Dr. Peterson's own lawyers are going to be there arguing for his specific interests, but we want to argue about the broader public interest in this case. We believe that professionals and employees are entitled to have their own private lives. They have a right to express themselves when they're wearing their personal hats, when they're living their personal lives. They have a right to criticize other people in their profession as well. They have a right to criticize others who put themselves out in public, like celebrities or politicians. And all of these rights are enhanced when a charter right is engaged because they are actually contributing to public discourse when they are making these types of public statements. They're contributing to public awareness, they're contributing to public dialogue, and all those types of expressive contributions are in the public interests. People in regulated professions have private lives outside of their professional roles. And any intrusion into the right of an individual to participate in public discourse, including by making even controversial statements on social media, if a regulator is going to sanction that, it needs to be rigorously examined to ensure that that regulator isn't overstepping their mandate. Because of the inherent value in individual expression, especially when the charter is engaged, we are arguing that professional regulators must provide a cogent and compelling analysis that regulating off-duty conduct, so conduct outside of actually engaging in the practice of psychology, for example, that it actually falls within their mandate. The regulator needs to show that the public interest in regulating that off-duty conduct is greater than the public interest in upholding a charter right. And this requires, we argue, a robust evaluation of all the contextual factors that situate and explain the off-duty speech and the nature of the profession in which that speech was expressed. One of the hallmarks of a vibrant democracy is an open and robust right to freedom of thought, freedom of conscience, and freedom of expression. Freedom of expression actually underpins most of our other constitutional rights and allows them to flourish. It allows citizens to hold people in power to account, to debate the architecture of our society, and even controversial speech has social value. This kind of expression shouldn't just be tolerated, it needs to be protected from unjustified state or regulatory intrusion. It's always in the controversial cases where that overstep is going to happen. And we believe that courts need to stand firm against allowing professional regulators to essentially be co-opted by activists who want to use them to punish people who hold views or ideas that they disagree with. So as I said, we have been granted intervener status at this judicial review to make these points. So a lot of you are really interested in this case. I get it, it's a really interesting case, and it's a really high profile individual who is at the core of this case. So a lot of you have asked me either by email or in the comments on these videos how you can watch this hearing taking place on Wednesday. And a number of the groups involved in the case actually made inquiries and requests for the court to provide a Zoom link so that people in the public can observe. Because the courtroom where this hearing is taking place in downtown Toronto is pretty small, and there are already at least 20 people who are automatically going to be in the room because they're either staff, lawyers, parties, or interveners. And that's not even including journalists. Unfortunately, the court denied this request to create a Zoom link, so there will not be a Zoom link. I know that's not the news any of you probably wanted to hear. It's very frustrating, but that was the decision of the court. But I will be attending in person, and I'm going to live tweet the proceedings, so you can follow my live tweets. I know it's not quite the same, but I do my best. You can find those at cvangein on Twitter. And after the hearing has concluded, I will also go live here on YouTube the way I did following in the evenings after the Public Order Emergency Commission, in the evening after our judicial review of the Emergencies Act. So if you subscribe to the channel, you will get an automatic notification when I'm going live. And just stay tuned on the evening of the 21st and you can watch it live. And of course, you can always catch it later. The videos, my live videos are always available to rewatch on this channel. You can also stay up to date on this case and all of our other cases by email if you sign up for our freedom updates at theccf.ca/freedom updates, and of course by subscribing to the channel and ringing the notification bell so that you always get the updates when I have them. And especially for this video, it's very important to ring the notification bell so you get notified when the live is taking place. I'm really looking forward to giving you updates about this hearing in June. I'm really looking forward to seeing everything in person. I wish all of you could watch it with me. And if you want to help with any of the costs associated with this case, you can make a tax-deductible charitable donation at theccf.ca/donate. Okay, that's all for this update. Thanks for watching, and let's keep fighting for freedom in Canada.